many routes to the termination of marriages. Whereas some people take the path of divorce, others are able to rely on annulments. Today on Law Express, we discuss annulment of marriages, where we take you through the grounds a party can rely on to bring a petition for annulment of a marriage. My name is Noella Seidu. This is Law Express. Don't go away.
Belinda Poman is a private legal practitioner who enjoys spending her free time baking, reading, listening to music, and traveling. Kofi Boateng is a private legal practitioner who enjoys playing tennis and spending time with friends and family. Noella Seidu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
So there are ways of bringing a marriage to an end, either through divorce or by the commencement of annulment proceedings.
Yeah, unless, of course, one party dies.
Yeah, so for divorce, the law would say that the marriage is valid, but then for some reasons that the law would recognize, a fundamental ground for dissolving a marriage would be that the marriage has broken down beyond reconciliation. And so for that, a petition will be filed for the marriage to be dissolved.
Okay. As
compared to annulment proceedings whereby the marriage is either void or voidable. So the marriage is invalid, and then annulment proceedings are commenced for the court to declare the marriage as being void or as have not happened in the first place.
Okay.
So those are the two routes to which a party can bring a marriage to an end in Ghana.
So in the case of divorce, there must be a valid marriage, and based on the ground that the marriage has broken down beyond reconciliation, you seek to terminate same.
Yes.
But in case of annulment, it's a defect by operation of the law,
yes,
where there is something that is not, that makes it invalid, and for which reason you apply for an annulment. And it's important to add at this point that when you annul a marriage, it is as if you were never married at all.
That is so.
It takes you back to your position before the marriage.
Yes.
So if you were a spinster before, that's where you are now. You are not a divorcee.
Yes.
If you were widowed before, you are still a widow and not a divorcee at this point. What are the reasons for which somebody may petition the courts for an annulment?
Where in instances where there has not been consummation of the marriage, which means that the parties have not been able to have sex due to willful refusal of a party.
Okay.
Usually the man, if he refuses to have sex with the woman.
The woman.
Or the woman?
Yeah.
Okay.
You do not think that it's possible that a woman would willfully refuse to have sex? I mean, women are humans. If the man can possibly decide to withhold sex intentionally and willfully, then a woman can do that too, and the man will have the same recourse. What qualifies as consummation of the marriage?
Okay.
I mean, yes, that is a side point of whether or not it's willful, just to put some context into the conversation.
Yes, so the law would say that there should have been sex between the husband and the wife for the marriage to be deemed to have been consummated. And so you cannot have oral sex and then say that the marriage has been consummated. It has to be the natural, known, and acknowledged means or ways of having sex.
Which leads to procreation.
Yes, which would lead to procreation, that the law would recognize
as consummation.
Otherwise,
so any other things you do from any other openings of the body wouldn't matter.
The law will not recognize that as consummation. There has to be the natural means of having sex between the husband and the wife. That's what the law would recognize as consummation.
So let me play the devil's advocate here. How about where you've consummated but with a condom? It counts, right?
It counts as consummation, yes. It counts as
because this is
consummation.
just contraceptives.
Yes.
But then you're still having sex in the normal way.
Yes.
Unless you wore the condom and used it for another way. And not the way that, the law expects.
Yeah, so once it's the normal course of having sex that the law recognizes and acknowledges, then that should amount to consummation of the marriage.
It's striking that the law zooms in on willful refusal of the respondent in this matter.
Yeah.
So the one complaining is saying that you have the capacity, you have the capability, you can engage in sexual activity, but you have withheld, refused willfully, not because you're under any pressure or under any problem?
Disability.
Yeah.
Disability,
but because you just decided not to consummate.
Yes.
And that is where this will be actionable, right?
Exactly.
So if you are impotent, on the other hand, that is not willful.
No.
That would not be willful, but then will the impotency prevent you from consummating the marriage?
Yeah, impotence, you just can't do anything.
Exactly. So if that is the case, then we would interrogate as to whether, well, it's not willful, but then you've not been able to consummate the marriage.
Okay, so but it's not available to a petitioner as a ground for annulment of the marriage because this person is not doing this willfully. It's a medical condition. Or some disability.
Well,
so probably
so
it can be there
the
for
void, but not voidable. It means that right from the onset, the law would deem the marriage not to have existed because you did not have the capacity to
fulfill all the requirements
of the law.
And then additionally, being sterile or being unable to ejaculate is irrelevant. So just because you had sex but you're unable to ejaculate or you couldn't reach an orgasm, didn't have sexual satisfaction, is irrelevant.
Okay. There just has to be consummation.
Yes.
Penetration and sex, simple,
exactly.
In simple terms.
I think it's important to pick out the fact that the law did not expect or does not expect people to be having sex before marriage, and it doesn't count.
Yeah.
That you were having sex before you got married.
So you wouldn't have known that the person is infertile, and that is why, I mean, if the person is not impotent and can still perform the function, it's irrelevant whether or not to procreate.
Sure.
You're pregnant to have children. That would be of no consequence at all.
Okay. The next point would...
And maybe before we step to the next point, I think it's important to note that with issues of consummation, there's no limitation period as to the time for which you can bring
the petition,
the nullity
proceedings.
Yes.
So it's quite open. It leaves room for people to manipulate. There appears to be a lacuna or a gap in that area that once the marriage has not been consummated, even if it's 10 years...
I kind of think there's a reason why the law allows for that. Yeah. In that, maybe the parties are so in love.
They agree.
One party says that I can forbear. For as long as you are with me, that is all that matters to me. Or for as long as we can explore other means of satisfaction or satisfying ourselves, I'm willing to stay. Then 10 years in, he or she realizes that this is not possible and they can't deal with it anymore. So they are allowed to, under the law.
Due to their age or the ages of the parties, they decide that we're going to get married but we won't have sex. A party may change their mind along the line.
You can't decide to get married and not have sex because consummation is fundamental to the validity. So then the
fact that the parties were able to have children through in vitro fertilization does not necessarily mean that there was consummation.
Yeah.
Because it happened outside the body and it was not as a result of penetration or sexual intercourse.
I'm just curious, assuming a woman comes to say that to the court that there's been no consummation and the man insists there was consummation, how do they prove that there was consummation? I mean, aside procreation, because procreation is not the ultimate proof that there was consummation. I mean, is the court going to put them in a space and then...
maybe there would be a scientific way of there should be a medical way of determining that. Yes. Maybe there should be medical experts calling to...
Listen, the woman has come in 2 years later to say there was no consummation.
Yes.
Now, the requirement of consummation is not a consistent thing.
Yes.
If you were able to consummate the night of the wedding, for instance, and you don't even do it subsequently, that it
the marriage is
counts.
valid.
It's a valid marriage.
Yes.
So how would science be able to,
well, it's
choose
possible.
a side?
These days, the science is far advanced. It's a possibility. I'm just thinking aloud, and
I mean, ultimately,
there might be a way around it through the scientific routes.
If it would not call for an annulment, then of course there will be an opportunity for divorce.
That is my point.
Because of the
Why you are saying
circumstances.
that there's unreasonable behavior based on the fact that the person is not giving you your sexual requests.
Yes.
We'll go for a break now. When we come back, we'll go on to the next ground for a petition for annulment. This is Law Express. Don't go away.
One of the grounds based on which a party can petition for an annulment is that at the time of the marriage, one of the parties or their spouse was of unsound mind or had recurrent insanity issues, if I should put it that way. So, and for that, you have to be able to apply to the court or petition to the court within a year from the period, from the time of the marriage or from the date of the marriage.
Okay.
Yes.
So then the next point or the next ground for which a party can stand on to commence nullity proceedings is the fact that the woman was pregnant for another man at the time of the marriage. And at the time of the marriage, the man was not aware of the fact that the woman was pregnant for another man. And so on that ground, the courts can declare such a marriage invalid and nullify
once again, you should bring it within 1 year of the marriage.
Yes.
And you shouldn't have consented to any sexual contact
subsequently
after you found out that your partner was pregnant for another man.
Yeah, exactly. So if you subsequently become aware of the fact that, well, I'm getting married to this woman, she's pregnant for another man, but I'm okay with it. I'm comfortable with it. I'm comfortable to accept her and her baby, and we become family, and you agree and you marry such a woman. You cannot come a year after and say that, oh, the marriage is not valid, and so it should be nullified. The court would not
I see where the law what the law intends to do in this situation to prevent the paternity fraud issues that we are seeing a lot these days. I mean, but there are limitations where it limits the period of your notice to just 1 year.
Exactly.
Is a bit, because many people get to know later.
I think you are having challenges with that, but I think as maybe the lawmaker feels that if for a year you're able to live with such a person peacefully, even if you didn't know of the facts, after a year you're able to live peacefully and comfortably, maybe the status quo should remain and the family should not be disturbed. Maybe that's the thinking of the lawmaker.
And, I mean, generally, the law doesn't want to make it so easy for spouses to walk away from their marriages, especially using annulment, which allows parties to apply for a nullity decree within a year. And I think it's an easier burden for parties than when it comes to marriage. So the law deems it as, or the law tries to protect the sanctity of marriage by not making it so easy for couples to seek nullity.
The next ground for a petition for nullification will be where the respondent at the time of the marriage was suffering from an incurable venereal disease in a communicable form. So first, it must be a venereal disease. It must be incurable, And it must be communicable.
Yes.
Which means that your life will be at risk if you continue to live with such a person. And the
You
law
will
would
definitely
make it-
contract it.
Exactly.
But once again, it still
The
falls
interesting bits.
under the fact that you should have known within a year
Yeah.
of the marriage.
Yes.
I mean, if you are required to consummate, at what point do you now know that, I'm sure probably after that you would have contracted it before you would know? That's technically
is-
the implication.
Yes. And then once you know,
You've already been given this disease, which is incurable.
Incurable. It should
and I think
Communicable.
what gets very tricky is the fact that once you know of this fact, you should not sleep with the
Yeah, you-
with
Person
your spouse
anymore.
Yeah,
anymore.
subsequently
Yes.
you shouldn't.
You
So
know,
that if you
so-
I mean, that's if
proceed-
you intend to nullify the marriage, you should not.
Yeah,
Sleep
after
with the person, yes.
knowing of the facts that the person has this venereal disease, which is infectious,
Incurable.
incurable, and then you still proceed. I love the person. I can't live without the person, and you know.
So just
Then
one
the-
consent to sex is enough to take away an opportunity to come for redress by way of nullification.
Yes.
I would say except
So, but then
fraud.
you're still open to going for a divorce. So the law is not preventing you from being separated from your spouse or but it would not be an annulment per se. Instead, you can go for a divorce,
divorce.
which may seem like a longer route, but
Once
you
It's
still
not
get
also
to.
automatic. You know that
Yes.
in
Yes,
cases
you
of
need to-
divorce, if you knew about, in fact, this one talks about 1 year within the marriage,
Yeah.
Yeah.
which is from when it starts.
Yes.
But in divorce, most times, what you're seeking to rely on, apart from cases of abuse and fraud and all of that, if this situation is such that you could have lived with, you're able to live with it for 6 months.
Yeah.
In that
Yes.
case, you're not even
Yeah.
talking about sexual intercourse.
Yes.
Living together for 6 months, you can't come back to
Yeah,
say that
complain.
the marriage has broken down
Beyond
beyond reconciliation,
reconciliation.
and you cannot be expected to continue to live together with this person.
Yes.
It gets even more
Yes, that is
complicated.
true.
So just like if you are filing for a divorce and your complaint is that your partner has committed adultery for which reason you are unable to live with a person, and then after knowledge of the fact that the person has committed adultery, you still have sex with the person,
Yes.
you live with the
Forgive
person,
them and
you
then
are
back.
okay, and then after 6 months you run to the court that the person has committed adultery, and so you are unable to live with the person, so the marriage should be dissolved. It will be difficult for the court to grant your request. And the interesting bits that we see in practice, the wife has filed a petition for divorce on the basis of adultery. Then as the proceedings are ongoing, you see that the wife is pregnant visibly in court. And so your case has ended.
How old is the pregnancy?
So obviously if the
Maybe
your
it's just
stomach
three.
is showing,
Maybe it's just 3 months.
If your
Okay,
stomach is showing.
it's not yet been 6 months.
if your tummy is, it cannot be hidden, it's all over the place. So the court cannot help you unless there's another ground on which you would come that the marriage should be dissolved. But if it's on the basis of adultery, then the petition would collapse.
In my understanding, annulment of marriage is a legal process used to separate two legally married couples, based on an activity or an act that has happened between them, and the constitution requires that they are being separated.
Yes, so annulment of marriage is the official process married people go through, especially when issues arise during the marriage and they think they cannot continue. So they have to go through a legal process to terminate the marriage. So therefore, they go through annulment.
So what I know about annulment of marriage is basically dissolving marriage. So in the case where a married couple decides that they no more want to remain married, what they have to do, that is if the marriage was a traditional marriage, is for them to go see the family of the woman. Because when the man was going into the marriage, he took a knocking drink to the family. So he has to go there and then request for his drink. However, if it is the ordinance or the court marriage, then one of the parties, the one beginning the divorce process, would have to talk to the lawyer. So you call your lawyer and tell the lawyer that, I'm no more interested in the marriage again. then they begin with the processes. One of the things that I know is that the person who is asking for the divorce would have to compensate the one who is to be divorced. That is, if the problem is coming from the one who is to be divorced. So basically, that is what I know about annulment of marriage.
So basically, in law, an annulment is a legal process of declaring a marriage that the parties thought existed null and void, which means that the law deems the marriage not to have existed at all in the first place. So even though the parties cohabited and they had done whatever processes or whatever necessary events for them to conclude that they were married, the law deems that arrangement or situation null and void.
So the law is basically saying that whatever took place never took place. Yes. It's been erased because it did not follow the required legal procedure. It did not follow the legal requirements that would make the marriage valid.
There were some new intervening facts that probably were not known to either the party, the petitioner, at the time of the marriage, or that have happened within the first year that make it void. So, for instance, you didn't know she probably was pregnant for somebody else. So within a year, you are able to tell that she was indeed pregnant, and you can tell from when, probably the age of the pregnancy, that perhaps it's not your pregnancy, and she didn't declare that to you at the time of the marriage. And so within the first year, upon knowledge of this, you could apply for an annulment once you do not have any sexual intercourse with her from the date that you found out about the facts of the ground that you intend to rely on. So I noticed that most of our viewers tend to mistaken divorce for annulment. And that is the very justification, the main justification for this particular episode, to let people know that there's a distinction between an annulment and a divorce. And after the fact of an annulment, you are restored back to your status before marriage. So you are not a divorcee. You are probably a spinster, widow, whatever. Unless you were divorced once before the marriage, then you continue to be that.
That is so.
I think we should go further into other grounds that people may rely on to apply for annulment.
Yes. So one very important ground that the courts can stand on to annul a marriage is the existence of a legally contracted marriage. So if there's already, so let's say party A gets married to party B under customary law, and then subsequently to that marriage, party B contracts an ordinance marriage with party C, the law would declare the second marriage as invalid, and so it would be annulled on the ground that there's a subsisting valid marriage. And it does not matter whether the previous marriage is a customary marriage or an ordinance marriage. The fact that it's a lawful marriage is recognized under our law as legal and lawful. The second marriage would be null and void, and so the court would annul a second marriage. And the interesting bit about these proceedings is that a third party can commence the annulment proceedings to bring this marriage to an end, so that, for instance, the first wife who was married under custom can commence nullity proceedings for a declaration to the fact that the second marriage between party B and C is null and void. Or even party C, who party B has gotten married to, after getting to know of the fact that there is already an existing marriage and that my marriage to party B is of no effect, can also commence proceedings for annulment. And so this is another ground under which a marriage would be declared null and void.
Additionally, in a situation where there is fraud and misrepresentation, for instance, if my name is Kofi Poatin and I go and marry somebody and tell them I'm Kofi Seidu, even though we may go through all the processes and get married, the marriage will be declared null and void because I may have misled or deceived the other party into believing that I am who I am not. And so in a situation like that, an annulment can be petitioned for.
How about situations where minors
Yes.
have gone to exaggerate their age?
Yes.
For instance, you've gone to lie that you're 21, so you can marry under the ordinance, because under that marriage you may not require your family to be present.
Yes.
So you wake up and you hear that your 19-year-old has gone to sign and married under the ordinance to somebody, some 40-year-old man,
Yes.
okay, who should have known better.
Yes.
Yeah, and then the parents at this point can petition for an annulment
Yes.
on grounds that this person was a minor and their consent was not sought,
Exactly.
you know, for the purpose of the marriage.
Yeah.
We will go for a quick break. When we return, we continue on the grounds for annulment, and then we can perhaps discuss the status of children born in a marriage that has now been annulled by virtue of the fact that we talked. We earlier mentioned that it's as if it never happened, but the children cannot be wished away.
Yeah.
This is Law Express. We'll be right back.
Another ground for which a marriage can be annulled is that the parties are related by blood, which the law would describe that as consanguinity. So if a brother and a sister for some strange reason get married, such a marriage would be declared as null and void because the law does not recognize such relationships. And then another ground would be issues of affinity. So there are relationships that are established through marriage, so that if, as a result of marriage,
You decide to marry your brother-in-law.
Exactly, the law would frown on that, and such a marriage would be declared null and void. And so those are other grounds for which the courts would hear a nullity proceeding and annul the marriage.
Great.
Also, where there is duress or coercion and a party is forced or threatened into a marriage against their will, that's also a ground based on which a marriage may be annulled.
So how does this come to play? Like a parent, by reason of some inducements, decides to compel or coerce their child
Against their will.
against their will
Yes.
to marry somebody because they feel indebted
Yes.
to that person, or because they think that by marrying you off to that person, you're going to live a better life,
Yes.
and this is not what you wish for.
Yes.
We have some questions
Okay.
coming by way of social media. Let's attempt to resolve them
Okay.
to the best of our ability, considering that it's just a few paragraphs and we do not have the people to ask follow-ups.
My wife and I married in 2019. After all these years, it has become clear that we cannot continue as husband and wife. My wife lied that she has an AA genotype. After the marriage, I found out that she is AS. I am AS, and that is why it mattered to me that my partner is AA to eliminate any risk of bearing kids with sickle cells. Since I learned about her genotype in 2020, I have kept it to myself. Can I ask her for an annulment based on this? I want to have children, but it would not be wise with her.
As we just discussed, issues of fraud. The law frowns a lot on fraud, misrepresentation. So the law would even say that fraud vitiates everything. So that if the marriage was contracted with facts that were not true, it was based on lies, misrepresentations. Per the grounds we've discussed on this platform, the man can commence annulment proceedings. But then, in this particular case of fraud, it makes the marriage void as compared to if the marriage is voidable. So once the marriage is void, then an application can be made for the marriage to be declared null and void.
No, but I agree with your position on this, but I do not think we have enough information, okay, to come to
conclude.
an absolute conclusion. Reason being that he's known this for 4 years.
Yeah.
Okay, he's lived with her for 4 years. Say for the fact that he says he keeps to himself.
Yeah.
Now, in keeping to himself, we do
Doesn't
not
mean he's
know
not having
if
sex with
he's
him.
not, having sex, or he's
Since
not
he
talking to
found
her,
out.
or he's just dull. So if he's been able to live with her for 4 years since finding out about
Yeah, the
finding out
incident.
about this fact, the marriage is not premised just on having children.
Yes.
And the law also would take into consideration other options available to a couple to have kids.
That is true.
You can
Yes.
adopt. If you must have them, biologically, you can get donor, specimen
Yeah.
for maybe an egg, or,
Yeah.
Yeah.
There are many ways around it. So I
Yes.
do not think it's absolute that the law would just truncate. Still, it sticks out that she lied.
Yeah.
Yes.
Okay, and that's a fraud bit.
Yeah.
But after you found out, what did
Yeah,
you
what
do
did you
about
do
it?
about it?
We had our wedding and signed in our church when we got married. It has been 5 years now since our wedding. We no longer get along and things are a mess. Last week, I went to pray at church and overheard plans to license our church ministers to legally officiate marriages. After some checks, it is clear that the pastor who officiated our marriage was not licensed to do so. Our church, which was still under construction then, was also yet to be licensed and registered. I want out of the marriage. Can I seek an annulment?
By law, there are certain requirements that a valid marriage have to abide by, and one of them is the fact that the venue of the marriage has to be licensed. And so based on what you just read, the venue or the church premises was not licensed, and that makes the marriage void.
Plus,
And
the
plus,
officiating
yeah,
minister.
officiating
the
minister is
was
also not-
licensed. And that is very fundamental to the validity of the marriage.
Yes.
Yeah.
It's not one of the conditions where one of the parties can decide to live with it or otherwise. This is fundamental, and it goes to the root of the marriage.
Yes.
So for these grounds, the marriage would be annulled because it's dead on arrival.
So for a minister of religion to qualify as a marriage officer, he or she, okay, ought to be appointed by the Minister of Interior,
Yes.
okay, and limited to a particular district. So
Yes.
you have a designated district, okay, and then you can be qualified
Yeah.
to officiate over valid marriages. In terms of the place of worship, is the district chief executives,
Yes.
okay, that's, or the municipal chief executives who license these places of worship for the purpose of celebration of valid marriages. So if these two do not align, clearly there is a technical reason why this marriage is not valid, and it's unfortunate that this was not your call.
Intention.
It wasn't your fault
Yes.
that this happened, but by operation of law,
Yeah.
this was not a valid marriage.
So it's important to note that the intentions of the parties are irrelevant when it comes to the lack of compliance
Yeah.
when it comes to the requirements of law.
And that's why it's important to, especially for Christian marriages, that you check
Yes.
for these
Yes.
things,
Yes.
okay? You need to ensure that the church probably exhibits or shows. When you go to commercial places, you see certificates of incorporation
Yeah.
displayed out
Yes.
there and other permits. I think churches
Should do the same.
give their congregants assurance
Yeah.
at the time of counseling.
Yes.
Run a copy.
Yeah.
Let them see that this is a validly registered venue
Yes.
and a validly registered minister.
Minister,
You know,
marriage officer.
just give them the assurance,
Yes.
especially where they do not even know
Yeah,
to
lots of
ask.
people-
You
Yes.
should be proactive, just like how you insist that they should be counseled
Yes.
Yeah.
before the marriage is celebrated. So we have talked about the fact that when a decree of nullity is granted
Yes.
to a petitioner in courts, the marriage is deemed to have never existed.
Yeah.
Okay, But then, like I said earlier on, you can't wish away children of the marriage.
Yes.
They are human beings, they are here. They can be seen and not, dispensed with.
Yes.
What is their status in terms of the law?
So the law tries to protect children from invalid marriages or void marriages. And so children that came from a marriage that the law has declared as void, has nullified, the law recognizes those children as having the same status as if the marriage of the parents had been dissolved but not annulled. And so the rights of the children of an annulled marriage would be the same rights if they were from a divorced
Yeah. So
marriage.
I think it speaks to issues regarding maintenance.
Yes.
Yeah. Because, whereas between the couple, property rights issues may not come up
Yes.
because of the fact that the marriage was deemed to have not started. Okay. But in terms of the kids, if there was any, they still have to be taken care
Yes.
of from, the parents' money,
Yes.
such that they have to be maintained, their fees have to be paid. And if the parties, one of them fails to do that, an application for maintenance can still be applied
Yes.
for.
Yes. So generally, in spite of the fact that the marriage was declared invalid, the law is that there is nothing like illegitimate children. The children will always have to be taken care of. Their needs would have to be met. They have rights that have to be protected. And so regardless of the status of the marriage, as she rightly said, the children would have to be maintained and the parents have to take responsibility for the maintenance of the children.
So in our law, a child is a child.
A child is a child.
Thank you for joining me on the show, Counsel. Today I was joined by Belinda Puamang and Kofi Boateng. My name is Noella Seidu and this has been Law Express.